Good evening. Welcome to the September 4th meeting of the Town of Orange Planning and Zoning Commission. Before we begin tonight's meeting, I'd like to point out the location of our emergency exits. The first one is to my right, your left, in the middle of the room, where most of us come in and exit the room. The other two are, again, to my right, your left. At the back of the room, there's a hallway. One of the exits is immediately upon entering the hallway. The other exit is at the end of the hallway. I'd like to ask those seated at the table to please introduce themselves.
Hi, Tammy Costello, Zoning Administrative Assistant.
Rick Miangioni.
Paul Kaplan. Ozzie Parenti.
Paul Denise, Zoning Officer.
I'm Commissioner Walter Clark, and Commissioner Judy Smith Morgan will be arriving late this evening. She had a business meeting, and she'll be here as soon as she can. The first item on tonight's agenda is an update of the Marsh Hill Road, Edison Road study. Paul?
The closing date to receive any proposals for the study was on Friday. We received 2 responses, one from Brian Miller, one from TPA, and I can circulate those among the...
If you could, and then we'll try to get some, we might as well schedule some meetings with those as soon as possible, some interviews with them, and then hopefully some others will come in the meantime. So we just got the 2?
Yes.
Okay. Why don't we try to schedule, what does the commission prefer as far as the interviews go? Do you want to try to do it prior to or during one of our regular meetings, or just prior to one of our regular meetings, or do you want to try to do it, say, 5 or 5:30 some evening? Any preference?
I would prefer to do it, not necessarily on, have to be on our meetings, but on Tuesdays.
Okay.
Because of other commitments that I have.
Okay. Yeah. That's fine with you, Rick?
If it's another Tuesday, I won't be here because I'm at another commission member.
Okay. Paul is aware of your schedule, though, for wetlands? Oh, every Tuesday or every other Tuesday?
Yeah.
Okay.
I'm here every Tuesday.
So Tuesday prior to one of our meetings, we can do interviews.
Or before the wetlands meeting, right? No?
Oh, yeah, if you want to do it before, that's fine, too. All right, yeah. Or a different day, doesn't matter.
Well, Tuesdays is kind of best for Paul's schedule. So why don't we work with Tuesdays and schedule them either prior to our meetings or prior to wetlands meetings. And we'll try to get those 2 interviews scheduled, and any others that come up, we'll try to, I don't know if we can get a couple in, before each meeting or not, but we'll do our best, and we'll try to get on that as soon as we can if we could. The next item on tonight's agenda is a discussion of the sign regulations. Before we really get into this into too much depth, I had called Paul Grimmer from the Economic Development Corporation and asked him to get together a pool of some business owners and also some property owners on the Post Road to have a meeting prior to really get into depth on this, to get different views on this. I know that there are some people who would like to address the commission regarding this tonight, and we might as well have a brief discussion on it now, but we do want to have a little bit deeper discussion after we get some different views as well. And that meeting hopefully is going to take place next Wednesday, I believe it is, the 12th. Would you like to come forward? I see Robert in the back. And I would like to say that the program that Paul has initiated with confiscating the signs that are placed illegally seems to be doing a tremendous benefit to the Post Road. And I think it also is discouraging merchants from putting out those type of signs.
Robert Kravitz, I spoke to you at the last meeting, and I would agree that the response has been excellent. I wrote a letter indicating that, to my eyes, there were no less than 50 illegal signs and banners, and they have diminished. For purposes of discussion, I'd like to also ask about sidewalk sales, tent sales, temporary business signs again. I'd like to bring that back up. And another issue I think that we should address is real estate signs, which I think are just nothing more than an extension of advertising. Those are the 4 things that come to my mind.
Sidewalk sales, real estate, and what was the?
Sidewalk sales, tent sales. This past weekend was Labor Day, and people just went hog wild. Better Bedding had a tent sale with sandwich board signs. A business called...
They were approved for a tent sale.
Okay, just asking. They also had the sandwich board signs out. Tent sales site. And there's a place called, I gotta think of it. It is Must Have Shoes. They've been running a sidewalk sale for really the whole summer. So it just, and I only mention it because everyone is pushing the envelope, and it just, I don't think it adds anything to the economic development of our community. I think it cheapens it, really, actually. So just questions about that. And I know it's Labor Day, and so, you know, Town Hall shut down, and I'm sure that's the reason why it all came back, but it's not there today. If I can, the last meeting, we spoke about the temporary business sign issue and the fact that a business called Spooky Town did get approved for a temporary sign. I adamantly disagree with that, any privileges being granted to a temporary business, and I really have nothing more to add from our last meeting, except I'd like to introduce a friend of mine, Art Linares, who is the owner of Party City. And at the last meeting I mentioned that the temporary business that is just, you know, springing up has a very negative impact on a legitimate businessman, and that would be Art. So is that within protocol?
Absolutely.
Yeah, because I mean, I think he can probably present his concerns better than I.
Thank you. I want to thank you for addressing this problem that we're having in town, and I want to thank Rob and thank you for all your efforts in considering that the situation that this town, I mean, that we're faced. I mean, Orange is a great town. We've been in business here since 1993, and it's we're in the process of looking to do an addition to the building, add on to the building, and, you know, keep building the reputation that we have. It's one of the best party stores actually in the country. And of course, with success comes the temporary business, and as you can see, that some of this signage that is being put out, we don't have. And I have letters in the past where we have put letters up, put up the necessary signage, and we have received letters that are actually, you know, threatening us with violations of $150 a day and so forth, so we took them down. It's like any other regular business would do that's in business in town. There's a big problem with these temporary stores that are coming in, and you really should consider some of the problems that could occur. You know, this certificate of occupancy issue. Are they paying their due course of taxes to the town like we do for, you know, our share? Do they have the proper fire coding too? That I know with the sprinkler system we have something that at this time of the year is very hard to maintain, and we do with the fire marshal regarding our sprinklers. I mean, this is flammable merchandise. I don't know. It's not on my, you know, I can't regulate what the town is doing. I'm trying to keep up with our portion.
Those safety concerns were some of the concerns that Paul echoed as well about the temporary businesses. And I did ask Mr. Marino to look into ways that we can, I think as we all know, we can't ban businesses from coming in and you know, even on a temporary basis, but there are probably ways to regulate that type of business so that we do eliminate the safety concerns. We don't have an answer for you right now, but we are, you know, looking into it.
But I think you really should also be aware that the town of Orange has 3 temporary stores that are opening up. You have Halloween Adventure, Halloween Experience, Spooky Town, and I think one of the reasons that that's happening in this town and it's not happening in other towns is because maybe the regulations are not as strict, and it's something for you to take into consideration. God forbid something does happen regarding the fire codes and so forth. You know, there's also Milford has a temporary store that's opening up, Spirit. And West Haven is also having Halloween Kingdom, so regardless, we got better pricing. I had to throw that in there. So. But I appreciate the fact that the committee is looking into this. I'll be happy to participate in that meeting next Wednesday.
If you contact Paul Grimmer?
Absolutely, I will.
Great.
And I thank you for your consideration on this, because it's something that it's, you know, as local business, it is affecting a local business, and it could happen with other businesses too in the future. Good.
Thank you
And I
very much,
for your time.
and we'll be speaking again, I'm sure.
Thank you.
While it's open, do any other commissioner members want to join in that meeting? If we have more than 3, we have to write it up as a special meeting, we have to announce it, so, but it doesn't mean we can't either. He's going to set it up for the 12th, I don't know if he had the time yet. I'm not sure if he set the time. 12th is next Wednesday, I believe it is.
Yeah, no, I may have commitments in the afternoon if it's in the morning.
What time, how late?
It's maybe like 2 o'clock or 1 o'clock.
So something, say, noonish or something would fit your schedule, or prior to that? Okay, I'll mention that to Paul Grimmer tomorrow, and I'll have him send you an email and put it in the loop there. Great, thank you. Any other discussions about the signs? There being none, we'll move on to a review of the minutes from the August 7th meeting, which we can't review till Judy arrives. And we'll move on to the August 21st meeting.
I had something. Let me, page 2. 3rd paragraph down.
Yeah, that should be you and not Judy.
No, I am in there. I think it should be with Paul.
Oh, Kaplan, you're right, yeah, it's Paul Kaplan, yes.
Right?
Yeah, you're right.
Okay.
In the 3rd paragraph, it says, Chairman Clark noted for the record, Commissioners Mangione and Smith Morgan were absent. It should be Commissioners Kaplan. And one other, Tammy, on page 3, Ernie LaJoya's name. It's L-A-G-O-J-A.
L-A-J-O-J-A.
L-A-G,
L-A-G.
yeah, O-J-A. We've got to change that in the 7th as well.
Bo, could I ask, for either the purposes of next hearing or at some point, you know, before the 12th, could I ask you to review, Paul, or get the a comparison between our regulations and a Milford for this, for the temporary businesses? I just want to see if there's any, you know, major discrepancies. Not that we have to be on the same page, but I'm curious
Right.
as to if there's
How they
a-
control it is,
Yeah.
or if they do, yeah. Going back to the August 21st meeting, minutes rather, we have those 2 corrections. Any other changes?
Well, I don't know about page 3. I know in the beginning of the meeting you stated that Judy will be coming later. The reason we couldn't do the August 7th minutes was because of said Judy and Brandy were not present this evening. Should you say she wasn't here yet, or because later on she is here?
We were not present at this time, instead of this evening?
Right, because she did show up.
Right.
Just so.
Because we still didn't have a quorum, that's why we didn't go back, because Ozzy wasn't here as well.
Right.
Okay. So we're going to change that to not present at this time.
Make a motion to approve the minutes as amended.
I'll second that.
All those in favor signify by saying aye. Aye. Yeah. Motion passes 3-0-1. And we'll go back to the August 7th meeting, hopefully maybe prior to the public hearing, but if not, afterwards. Moving on to old business. Does anybody have anything under old business?
Bo, for the last hearing, we had listened to some testimony regarding a cease and desist that was issued on the Cosa Creo property, I think it was. Any update on that, Paul?
We had a meeting here at Town Hall where our town council was present and also the attorney for the Casa Creos. We're still going ahead with the matter. However, there were certain recommendations that were made to them which would possibly resolve the situation before it got too far, mostly in terms of a schedule that they could keep to abate the violations up there and to remedy the disturbances.
It appears overall they've been cooperating? I'm asking.
Well, they showed up with the attorney, and they seem to be cooperative. Again, part of that timetable has to be met, and that is that we're supposed to be furnished in the near future with an engineer who's going to represent them and formulate a plan as to what's going to happen up there.
Was there more moving activity with regard to earth removal and so
No,
forth?
I have not seen any evidence. I have not been out this week, but I was out last week.
And the engineer is to present a remediation plan, correct?
Right, that's the whole intent. The engineer would ultimately come up with a plan.
Okay. And they have a deadline as far as the engineer's plan as well, if I recall.
Yes.
Anything else under old business? Is there anything under new business? Hearing none, we'll go to the report of the zoning enforcement officer.
I've already spoken on the Casa Creo issue. We made a number of inspections up there, and it's a large site. An inspection takes a while. If you just walk in and walk out, it's an hour. If you walk in and take a look around, you're talking 2 hours, 2.5 hours. But at any rate, we had that meeting, and hopefully there'll be some action on that. Also made a major inspection down at Springbrook Commons with Russ Smith, who's the developer down there, and they're really coming along. They've got the rough grading in. They're going to be asphalting in the near future, and everything's going according to plan. There is one issue, and that is with the interconnection to Christmas tree shops. Christmas tree shops had, in the past, agreed to the interconnection, and all the evidence since is that they're still agreeable to it. However, they seem to be dragging their feet as far as signing or entering into an agreement for a formal easement between the two properties.
Should we send them a letter?
Yeah, we can. We can't force them, however.
No, I understand that, but remind them that the whole reason that it's good to do this now is that it'll save them some cash later on for anything that they come to.
And they've also got a response from Webster Bank with regard to the site plan you recently approved.
Was it a positive response?
It's a response which is a lot more than what happened in the past. And I think once we start talking, again, logically, there's no other way to go for them. I mean, they're going to have to pay for it in the future if the interconnection isn't made now, and if it's made now, it's at no cost to Webster Bank. So.
And again, this was pointed out too, that this was police and fire who also endorsed having the interconnection there. It's not just our wanting to have it there or the applicant wanting to have it there. So.
I also had a meeting with property owner Patsy Santangelo. Basically, the two items that have to be done down there is the striping of the parking lot and the installation of landscaping. And he has said that's all going to occur within 3 weeks. He says he wants the CO in 3 weeks to open up. Well, we generally don't like to see the landscaping installed in August. If there's any way to prevent that from going in August, we wait till September because the temperatures are cooler and the chances of the landscaping surviving is much higher. So the landscaping is going to be in within the next 3 weeks, and the only other thing that has to be accomplished after that is the paving of the parking area. Whether he finishes the interior of the building is pretty much done. It's just a matter of some small touches and mounting of electrical lamps, and but all the major work in the interior of the structure is done. So, but I don't know. So Patsy again takes his time, and he's posted a bond. He's still under the requirements, and but sometimes you see him there for a few hours. Sometimes they miss a day, but that's the way the job's been progressing. But the landscaping should be in within 3 weeks, and the parking lot should be striped.
Well, I know this weekend was the Odyssey at the Greek Orthodox Church. I take it there were no issues there?
I didn't receive
Really
any calls. In discussing it with other individuals, it went well, and didn't seem to be any incidences. And they usually have a big staff there. I did stop over late on Friday, and people were going in there, and they had good traffic management, and I didn't have any issues. I wasn't there on Saturday Sunday
Yeah.
when they got bigger crowds, but,
It's generally very well run.
yes.
Okay. Any questions for Paul? I guess at this time we'll take a brief recess and resume at 8 o'clock for our public hearing. Good evening. Welcome back to the meeting. At this time, we're going to begin the public hearing portion of our meeting. Before we do, I noticed there are several more people that have entered the room. I'd like to point out again the location of our emergency exits. They are the main entrance and exit to my right, your left, in the middle of the room. The other two are located in the hallway to the rear of the room, again to my right, your left. The first one immediately on the left upon entering the hallway, the second one at the end of the hallway. The first agenda item on the public hearing is a special permit application for the conversion of a single-family dwelling to accommodate an elderly apartment. This will be continued until our September 17th meeting, correct, Paul?
Yes.
The applicant is in ZBA right now and should have their answer from them. The second items are the petition to amend the Orange zoning regulations, a special permit application, a site plan application, and an application for temporary special earth materials and filling, an application for certificate of soil erosion and sediment control, and a re-subdivision application submitted by property owner Sunrise Hill Estates, LLC. Would the applicant like to come forward, please?
Good evening,
evening.
Mr. Chairman, Mr. Denise, ladies and gentlemen of the Commission. For the record, my name, Mr. Miller, good evening. My name is Joe Porto. I represent the applicant, Anderson Wilcox Corporation, regarding the matter that is now in front of you. Just a couple of housekeeping matters, Mr. Chairman. We did, in accordance with the recommendation from 2 weeks ago, amend the regulation. I sent an amendment to Mr. Denise on the 30th of August. If you would like, I can briefly go through the points
If you would.
that were changed. Sure. The first change is that we stated that a household member, if a divorce occurs, you might recall there's some conversation about what would happen if there was a divorce. Well, if there is a divorce and the couple was previously qualifying, that is to say one member, one spouse was over age 55, and if there was a divorce and the court saw fit to have the spouse that's under age 55 stay in the active adult community, that person would be a qualifying occupant. We further define the regulations to state that no one under the age of 21 years of age, 21 years old, can reside in the active adult community, and for that person to be considered permanently residing, they would have to be a resident for 6 months or more.
Can I interrupt you for 1 minute?
Of course.
1 moment. Going back to the first one, under A2, it now reads, a single household member may also be under age 55 or if he or she is a divorcee of the previously qualifying occupant. I'm guessing, and please correct me if I'm wrong, that it specifies single because if that person were to be remarried to somebody else who is under 55, then they would then have to move out. Is that correct?
Well, the way I interpret these regulations, the answer to that specific question would actually be no, because that person would be qualifying. So they would be, quote-unquote, grandfathered in. They would have been a qualifying spouse of someone that was over the age of 55.
Right.
And as long as they were to marry someone who was over 21,
Right. Then they're okay.
then they're okay.
Okay.
If they had a kid, that's no good.
If they had a kid,
They've
then
got
they
6
bounce
months
out,
to go out. Okay.
which is what I'm getting to right now.
Okay. Sorry to interrupt.
No, no worries. And paragraph A5 has been reworked to state specifically that any couple or resident, if they adopt, have born unto them, or otherwise come into possession of, a child that is under the age of 21, who is going to be there for more than 6 months, then they must make accommodations to move out. Paragraph A6 has been created to state that the community association which will be formed, should this commission see fit to grant this application, and that association should have, will have the powers to enforce the regulations as we propose they be amended, as well as all the powers set forth in the declaration documents. We have made an effort at defining a MU, which is a semi-private service driveway or an alley. Paragraph J1 has been revised to state that specifically the active adult community shall contain a mix of housing types with a specific emphasis placed on variations of exterior facades, materials, and colors. That, of course, is done to make sure that we don't have a similar houses in a row, similar looking units in a row. And lastly, paragraph K5 has been revised to state that to address the issue of different types of space, that is to say undeveloped natural areas, wetlands, and landscaped have been separated from recreational and community buildings. And we've indicated that both must be, I believe, 400 square feet per unit. Let me check that real quick. That is correct. So those are the changes which I believe addressed the points that were brought up 2 weeks ago. And as I indicated last time, we've had the opportunity to put on all our experts. I believe we've put in all our evidence. Mr. Gordon is with me this evening. I'm certain he would relish the opportunity to speak to you for a little while, and together we'll respond to any questions that the Commission may have.
I have one question before you leave. We discussed that there were going to be 11 units that were going to be market controlled, I guess we'll use that phrase.
Correct.
Do you have a plan or a statement as to how they're going to be market controlled? In other words,
go ahead.
In other words, yeah, I think you mentioned they would only be allowed to increase the price by a certain percentage per year and so on. Do you have that drawn out in a statement that you could submit as evidence to the board, that this is the way that these particular units are going to be market controlled? That
is going to be in the declaration. I don't have it with me, but yeah, I can get it for you. The answer is, yeah, or I can send it to Attorney Marino.
Okay, Attorney Marino was in the room. Okay.
I believe he's going to be back.
Okay, because I have another question for Mr. Marino as well. One of them is we had the, Mr. Gordon assured us that there was going to be water pressure. I believe in the minutes it was up to 68 pounds. But perhaps if we're going to adopt this type of regulation, we should mandate that any development of this, because these buildings are close together, that we have a minimum water pressure of, say, 60 pounds, which the testimony is that this will be in excess of 60 pounds, but perhaps we should include that minimum in our regulations.
Is that, I have heard no testimony, is that the requirement in other?
It's not a requirement, but you have to have a certain amount of water pressure for sprinkler systems to work and to have good protection and actually good water service for the residents.
Is 60 pounds going to do it is the question?
Well, I believe 60 pounds would be more than sufficient. It's probably well over what you get from most wells, first of all. And
you might want to phrase that, though, instead of saying, specifying a certain pounds per square inch, identify the
pressure
sufficient to sufficient to assure that sufficient
to assure fire protection.
Exactly.
In the opinion of the fire marshal, right?
Yeah. Okay. So if we get to that point, I'd like to incorporate that into some type of a regulation if we go there.
I would also note that we received letters from both police and fire addressing that cul-de-sac extension. I presume they've made their way into the record.
Right, they did, and that's to do with the subdivision application portion of this, because we have to, if we go forward with this, again, we discussed the extension of the cul-de-sac, which would be in excess of the 1,400 feet, which is our limit, but we do have the ability to waive that limit and go forward. Another thing I wanted to address, and maybe Mr. Gordon did address it and I didn't catch it, but there are going to be recreational facilities proposed to do with this project. And I also know that this is a 5-year project, I believe, for completion. At what point will the recreational facilities be in place?
For the record, my name is Jeff Gordon with Codis Bodie and Associates, 504 Boston Post Road here in the town of Orange. On the revised sheet SP4, the Master Soil Erosion and Sediment Control Plan, there is a phasing analysis that's been done, and it doesn't come in completely early on because this area, the parking lot for the community building is actually one of the site construction accesses, so we don't want to, we're trying to get them away from the main entrance. When people start to look at it and have model homes, we don't want to have the construction equipment going by them, so we bring a construction access through here, so that's why part of this will be built early on, but it will not really be open to use. I have removal of the construction entrance at the community building site and construct all of that in about midway through the third phase.
Midway through the third phase.
Right.
Which is at least a couple of years.
Well, it depends on how the market's going. Usually when things are going well, one phase rolls right into the next phase, but the point of that being is that is a logical construction entrance that doesn't step on the feet of the main entrance once it's built and the houses are built in that opening corridor. So once we have enough of the road network established, we can pull that out because we're not going to worry about driving over unpaved roads and bringing soils all over the place. So we'll be building some of these structures a little bit early, but we're not going to have it really open to the public too early while there's still truck traffic going through there, if that answers your question.
Paul, in a case like this where it's a private development, do we hold a bond to ensure that these facilities would get built or not typically?
I would say it's probably a portion of the construction is incorporated into the bond. We're more concerned with the road construction,
Yeah.
infrastructure, sewers, those types of things. If you're looking for protection of who's going to buy the home there, if they don't get a swimming pool or a tennis court,
yeah.
that's not really the purpose of the bond.
Okay. And lastly, I know that the applicant has stated that all of these homes will be sprinkled, and of course we could make that a condition of approval, but I think if we're going to adopt this type of regulation, that should be incorporated into the regulations, that any type of this development be serviced with sprinklers. Those are some of the concerns that I have. Do any other commission members have any questions or concerns for the applicant?
Just back to Paul for the bonding. Why wouldn't, we're approving, if there's a project that's approved, it's approved as a whole. So shouldn't it be bonded to make sure it's completed? I mean, especially because if they default and leave, someone else has to pick up what's there.
I guess you can, you as a commission could require that be incorporated in the bond. Normally the bond is related to all site work,
Right,
infrastructure,
that's a
drainage
standard
facilities.
bond, right.
Right.
Well, I would think this project's a little bit.
Well, that's what I was
Above
going.
that.
That's where I was going to. We wanted to discuss is a way to protect people who may purchase homes in the early stages, and things happen. Businesses go out of business, and just to protect their investment if possible. I don't know if we can legally do it. I don't know if we have the power as a zoning authority to do that. And maybe Attorney Marino could comment on that.
Normally, what I'd say is to the extent that you get agreement from the developer, you can make anything you want a condition of approval. What I would suggest in the first instance is reach out to the developer and see if they would consent to such a bond. It would make matters much easier. If you're looking for a legal response, I would say I'll get back to you.
Okay.
Okay? Yes, for the record, Vincent Marino, the town attorney.
Again, as to the matter of the tennis courts, the pool, and the community building, we could build some of those elements earlier, but it's the parking lot access by which the trucks are going, so,
Okay.
you know, you could have certain of these elements in place, even though they're not generally open to the users at that
I
time.
think that would be a good way to work it if we, if we go down that route. We could have them built after a certain percentage of the units are in perhaps, with the understanding that obviously it won't be open for service, but the facilities themselves could be in place.
Mr. Chairman? I also believe that you can, like you was starting to say, that you could set thresholds that by a certain number of units being built, something has to be in place, and that may be some sort of alternative or use in conjunction with the bond.
Okay.
Thank you.
Are there any other questions or concerns from the commissioners?
I don't know if this would be for Jeff or Mr. Porto. Is there any provision or thought to golf cart use on the property? I know in some of the communities down south, they utilize carts to go visit home to home. I didn't know if you'd thought about that for this property, or if that would be strictly prohibited. And I had asked early on what the speed limit would be for the development, and you thought 10 to 15, or is...
Right. As for the golf carts, no, I never thought of that.
But a handicapped individual who has a motorized vehicle, that's always...
Right. So, I think the point is that any person that was handicapped, that required assistance in that way, I mean, that would obviously be something that would be prohibited and permitted. But I would also point out that the regulations don't prohibit anything either. So my sense would be that that would have to be something left to the association. And if that were found to be a problem in some way, either be a danger to other pedestrians, because this is a walkable community, and if we had somebody that was buzzing around in a golf cart and others felt that there was some risk, then that would be something the association would address, kind of point specifically. Of course, the exception being, as we just pointed out, that someone that required assistance would obviously be entitled to keep whatever vehicle they had. And yeah, and the speed limit, we're 10 miles an hour.
Well, before you leave, I got a question for you.
Great.
On for occupancy, A5, you have with reasonable time. If someone's a child under age 21, what would reasonable time be?
Well, the thinking there is that they would have to be able to have enough time to list it and also purchase another home. So while that would be an event that would trigger an expulsion, for lack of a better word, we don't want to make it so penal that they find themselves on the street. So again, reasonable time would have to be a term that would ultimately be defined by the association. Specifically, I don't have a number in mind, but I would think something in the neighborhood of months would be within the realm of reasonable.
No, just, I'm not an attorney, reasonable time could be
Again, I would think that
forever.
perhaps we could put that in our regulations, reasonable time, because I don't think that's something we want to be left up to the homeowners association.
Right, because it's anyone's discretion what reasonable time is.
Exactly. So I think that's something that if we move forward with this, that we should set a time limit on that, not leave that up to the homeowners association.
Yeah.
Brian, are you aware of any similar communities where they have a time limit, and if so, do you know what the time limits are?
I'll get back to you on that. I'm not aware of any specific time limits like that. I think it's, that other regulations have provisions for hardship. And I'm not sure it's been a huge problem anyplace either. So I'll look into some of the other communities, but I'm pretty sure that there's not a specific time period.
I'm just going to just make a comment about, with caution to the board, that if we're going to put in a hard and fast rule instead of a mechanism to determine what reasonable is going to be, it's really going to be without regard to the market forces that are in play there, because that's going to have something to do with it. Obviously, in a seller's market, which we're, not in right now, it may go quicker. But in some markets, it may go slower, and there may be more time. Reasonable may be one number in a down market and one number in a different market. So I'm just saying that if we're going to discuss this, we should have a little bit of sensitivity to that as well. Aside from the fact that you're going to be selling to a relatively, I don't want to say small, but certainly smaller than the entire universe of potential buyers out there, it's going to be a restricted, situation, so there will be less people.
The way I read this, I wasn't so sure that you needed 5 in light of the fact that you had 4. I mean, 4 just lays down the rule that, no one under 21 can be an occupant in one of these units.
Right.
So with that in mind, I mean, if the event or events that you identify in 5 occur, then at some point, the occupant has to realize that they no longer are welcome in the community, and need to make arrangements to leave. If they don't do it in an expeditious way, the town is going to be in a position to enforce the regulation.
And I would point out that, as you just said, people are going to be moving into this to not be around children. So to the extent that an unfortunate circumstance should occur where grandparents may have to become the guardians of children, that's going to be an exception. That's not going to be the rule. So what we're saying here is, over the course of 20 years, if this happens once or twice, I'd be surprised.
But there in that situation, you describe some emergency occupant type
for a limited basis,
which is covered under paragraph 4. But what I'm saying is, if you didn't have paragraph 5, then you take out this element of community board association control, and then it becomes a a rule that's
they revert it back to the town.
Yeah, the town enforces its zoning regulations, so that if again the situation presented itself where you had a person living there under 21 who wasn't there as a result of some emergency situation, then it would be up to the town to take the appropriate enforcement action to, I didn't think 5 added a whole lot to the discussion, and probably creates some problems that, we might not want to go along with,
Well, I think number 4 should be reduced to 3 months, not even 6, because if you're back from college, you're not home for 6 months. And you don't want a situation when the kid is there for 6 months, takes off for a month or 2, and comes back and says, I'm not a resident, I just came back. I mean, he could do that back and forth.
This might be a good thing for Brian to give some thought to, on as to how those 4 and 5 work together.
I think in that circumstance, Rick, whether it's 3 months, 4 months, 2 months, if somebody wants to play that game, they're going to be able to play that game anyway.
Yeah, but I just think it's going to happen because of the age of 55. You're going to have more children there, because they're not really all finished with college yet. They're still around, the kids.
Well, I think that you may have a little game playing for students who aren't in the public schools. But frankly, if they're a resident, if they're going to the schools in the town of Orange, they're residents. They have to list an address. So if the address is at this location, we know they're permanent residents. And it's a little fuzzy on the 18 to 21, but frankly, I think it's a little less critical, too. So, I've always said if there's school buses pulling up into the development, then Paul ought to get a call and go out and see what's going on. But I think the points about A4 and A5 as being a little awkward, perhaps. I will look at it. I mean, it's been done before, and the more I think about it, I don't recall that time period, that reasonable time period. I think you're right, Ozzy. I think if it's a violation, there's hardship provisions. If there's a violation, it's a violation, and it moves forward. And frankly, zoning violations, as I understand it, don't get resolved in a matter of weeks anyway. There's all sorts of time periods where things can get resolved.
The only, I agree, and I think Oz's comments are well taken. The only thing is that this particular zoning violation, as opposed to other zoning violations, is going to trigger a sale of this property. And I think we have to be a little bit more sensitive to that, rather than just a landscaper who, parked things on his, inappropriate things on his
But I think
lawn.
like Ozzy suggested, if we worded it the way he had suggested, that would revert it back to the Planning and Zoning Commission for a decision on it, and we can, we or our people who...
Use your discretion.
Yes, yeah. So Ozzy, your suggestion would be to scratch 5 altogether?
Well, yeah, I mean, again, Brian's got a little more experience with regulations of this type. I mean, I'd want him to take a look at it, make sure we weren't missing something by doing that. But yeah, I think, I don't think 5 really adds much, given subsection 4. In fact, again, I think it, by making reference to the community board, the association, and giving them some discretion.
But we can make that decision. We don't have
Yeah.
to do it, in accordance to other regulations in other towns. We can make that decision on our own, and I don't think it's something we have to research. I think we
Yeah,
should
no, I would
go
take,
forward with what this commission feels comfortable if we should, so choose.
I would take 5 out, yeah.
Are there any other questions or comments from the commissioners? Any questions or comments from the public for the applicant? Please come forward, state your name.
Warren Mulston, 81 Red Cedar Circle. Warren Mulston, M-U-L-S-T-O-N. I'd like to speak after 10 years of experience at Silverbrook 2, and I think a lot of the discussion that you're dealing with right now is unnecessary. I believe the declarant or the builder will provide a set of bylaws and rules and regulations that the association would have to deal with after the LLC is dissolved. And that's what we have. I don't believe that the town has ever been asked to step in and take care of any of our problems. And I don't think that that should be a responsibility that would be passed on to Paul. Of course, I also think that using 62 as a minimum age, as the age restriction, would certainly resolve a lot of these problems, because I don't think you would have college students coming back. As a matter of fact, a lot of information was presented at your last meeting regarding the demographics of 55-year-olds and how that number is increasing. I think much more significant would have been to take a statistical sampling of that age group and polling them to find out when they planned to buy or purchase a condominium. And I doubt that many of them would do it before they retired. And so I'm just leaving this sort of input with you. I believe that the bylaws that they would leave with the association when they go would be more than adequate to cover any of these regulations, plus an executive board and all the rules and regulations governing them. The executive board would have an immediate finger on any of the problems that develop, and they would have the power to take care of whatever problems occur.
My assumption is, and we have plenty of lawyers in the room that can answer this, is that if we don't have a mechanism in our regulation to enforce it, if the executive board of the homeowners association chose to, say, allow people of age 21 to live there for 4 years or so, if we don't have some type of mechanism to specify what, or to at least give us the authority to address that, then we could not address that at any future date. And if the homeowners association chose, wouldn't anticipate it, but if they did so choose to allow people of age 21, say, to live there for 4 years, we would therefore no longer have the authority to do it because we didn't have it addressed in our regulations, which, and You know, as I said, we've got attorneys here to tell me if I'm wrong or not, but that's the way that was my concern with it.
Put it this way, I wouldn't want to guess.
Yeah.
I would put it in there as a last resort if they had issues that we had to resolve.
Yeah, that's why I thought if we have it in the regulation, then if, you know, if the authority, homeowners authority doesn't resolve it, or doesn't resolve it to our liking, that we do have the authority to use our own discretion to enforce it.
At Silverbrook, in the declaration, it states specifically that the homeowner must be 62, spouse can be no younger than 55, that a family, and it specifically states that a family is a single household unit, which means a husband and wife. In one instance, it was a brother and sister where the sister was a caregiver. But we have 2 people are allowed at Silverbrook, and that's all. We are allowed to have visitors for 30 days. That's a maximum. And because of a family problem, someone can stay there as long as 3 months, but they pay an additional charge because of the services that they receive. And so these are all stipulated, and I believe that, personally, I think that it would be much more efficient for an executive board to handle these problems than transfer it to the town.
I wouldn't look for the town to handle the day-to-day operations. I would look for the executive board to handle that on a regular basis, and just in an emergency situation, to have the town to have the authority to step in is where I was going with that in the regulation.
But the big difference is his association is 62 and 55. Over here, you could be 55 and married to a 30-year-old.
Well, that's why
Or that's why those will have more issues with this type of, your situation's a lot better.
Well, I don't think you've established the age restriction yet, or have you?
No, we haven't established anything at this point.
So that's one of the reasons that I injected this information.
Right. We're listening, but I mean, there is clearly a difference between an active adult community and a senior community, and while they are both age restricted, there is a big difference between them.
Right. And it's not that until you decide what the age will be. Thank you.
Would anybody else like to come forward? Please come forward, state your name.
I'm Bob Gillette from Old Silo Road. I haven't been to any of these meetings before, and I'm not familiar with the covenants as they're written. My experience is I spent 5 years as the vice president of a homeowners association in Maryland. I was the original homeowner. However, there were a lot of homes that had turned over at least once when I was there. When we talk about the town possibly taking the action to enforce some of the things, we are putting ourselves in a possible liability issue as far as legal fees. We had quite a bit of problems with people, even though the board lived up to the covenants that we had as far as what homeowners could and could not do. And some of the homeowners basically turned around and said, sue us. Then you have to get special association fees. I'm not familiar with Silverbrook and how they work, and I hope it works much better, but we had a tremendous amount of legal fees that we had to pay in order to get homeowners to do different things that were in accordance with our bylaws. And some of the bylaws that we had is when they said the LLC leaves, when it's all turned over to the homeowners, we have to do it ourselves. We did have some problems. We had problems getting, fees from the homeowners themselves. And again, we were a lot younger community than 55 and older, or 62 and over, or whatever the case may be. But we ran into some very substantial legal fees that we had to pay to get different people to do all sorts of different things that our bylaws said they couldn't. So something I think should be thought out very well with the possible financial repercussions that may occur. Thank you.
Ben, do you have any comment on that?
With respect to the,
Well, if we as we've stated before, kind of left it vague as far as addressing that it is to be left completely up to the board, the community board. Would that put the town in a circumstance where they might have to enforce that and incur the legal costs? Or would it still be incurred by the homeowners association?
In all projects, this project being no different, there's always the potential risk, of the town having to do something and incur an additional expense for the benefit of what is deemed the community at large. Classic example would be what your tax assessor does for your affordable housing application. Every time an affordable housing unit is sold, there's a whole analysis that he has to undertake by accepting data from the potential purchaser. And although you're paying his salary, there's an administrative cost associated with that. So we get yelled at in court for that.
But Vin, wouldn't that be, I mean, they're drafting a new regulation, and if it was a violation of that regulation, to my way of thinking, it would be up to Paul to enforce it, meaning the town of Orange.
Correct.
And it cost what it cost, and I assume there's a mechanism to pass that along to the homeowner, the violating homeowners.
Well, you would issue a notice of violation, levy a fine. There are two approaches. One is the handoff approach, and to say, we are not the regulator of this. You have a deed restriction. It's in your declaration. You are to enforce it. And the town takes a hands-off approach. If the town wants to be more intimately involved with the project, as we are on a number of occasions with through the tax assessor, then that's the direction you take. I don't know if your zoning enforcement officer can really be there on a daily basis, on a monthly basis, on an annual basis, to review this data and really be effective to make sure that it's followed through. I think it's best laid at the feet of the association.
And I would expect them, as we kind of feel our way around through this process and live with this for a while, I would expect that we would take our cues from the individual homeowners association, meaning if the association asked for our help, meaning the towns, in particular situations, if we found it to be a violation, I would expect us to act accordingly, but that we're not going to interject ourselves unless there's an unbelievable situation, that we would expect the association to take care of most of the day-to-day operations, including the non-payers, meaning the...
Exactly. I would never anticipate the town having to manage this development. It's more of keeping a mechanism to, where it says here, the reasonable time period. That's the part that really initiated this discussion, and that's the part I have concern with, is I think the town would want to be the one to make a determination of what's a reasonable time period.
If someone had a child there, for some reason they said, going to the Orange school system, I want the bus to pick them up, association, they say, go ahead and sue me. What happens to that child? They get to go to school?
If the child is residing there at the time, but of course the child would have the right to go to school.
Well, I know, but then the legal fees would go to the town or them? How would that happen? I mean, according to what the guy said, they say, go ahead and sue me. It could take a long time.
Well, I know, for instance, in our lake association, if you do not pay dues, of course you you automatically lose your lake rights. Additionally, because it's in your deed, we put a lien on your home right away. So anything that would incur, now if we incur legal expenses to go after these things, we do our best to pass those along as well. Luckily we haven't had to enforce it in court, but we have taken action before.
It's a zoning violation, so you can't keep the child out of school, but you proceed as a zoning violation, just like you do with signs, is a good example. And it's the notice of violation, as Attorney Marino just cited, and and it may have to go through court, and the child may be in school for a semester or two while that's all happening. But I mean, that's the procedure.
The point is, you're laying out some basic parameters here. You're talking about what the 55 or 62, whatever. You're laying down a minimum standard, and it's that standard that you're not giving you're not willing to give discretion to the homeowners association to change in any way.
That's exactly right.
And it's the same thing with respect to the 21, you don't want anybody younger than 21 living there. That's a standard that, that the regulations will provide. Now, to the extent then that, you're not trying to micromanage the association, you don't want to take on the day-to-day responsibility associated with that,
Absolutely not.
but you don't want anybody under 21 living there.
Right, and nor do we want the association to have the authority to even adjust that.
That's the minimum standard.
I think there's going to be some overlap. I mean, as much as we're looking to cut it out, we're just creating another layer of, I don't want to say governmental oversight, but oversight within the community. And to the extent that we can, we're not going to have the overlap, but, it's going to be there at some point or another, and we'll just deal with it.
Okay.
Just on another point, I sent an email to one of my associates who are looking into that bond issue. So actually, I'm hoping told him I needed a response by 9 o'clock. So we'll see. But I was reading the statutes, and although not directly on point, under 8-26C, subsection C, subsection C, for purposes of the bond, and this is the subdivision statute, the subdivision statute defines work for purposes of bonding as work for purposes of this section means all physical improvements required by the approved plan other than the staking out of lots, and includes but is not limited to the construction of roads, storm drainage facilities, and water and sewer lines, the setting aside of open space and recreation areas, installation of telephone and electrical services, planting of trees or other landscaping, and installation of retaining walls or other structures. So to the extent that you'd be seeking to include in the bond the construction of the recreation facility, it seems like it would fall within that definition. But if you wanted to include in the bond the actual development of the house itself,
Right.
The answer would be no.
Okay.
All right, and that's just a cursory, but hopefully by 9 o'clock we have a more learned
Thank you.
answer.
Okay. Thank you. Would anybody else like to come forward and address the commission? Please come forward.
Michael Schwartz, 1006 Grassy Hill Road. I just have a couple of quick, questions or considerations. It's my understanding there's a age-restricted community in West Haven that was restricted for a couple of years and wound up changing and went back to a, age-unrestricted facility. So my concern would be that as these regulations are getting hammered out, we want to make sure that this can't happen, because one of the key things about having the senior complex that's appealing is tax revenue without school impact. But if it becomes unrestricted, we could wind up with a situation where you've got 142 units, average 1 or 2 kids. That can be very impactful to the town. So,
Yeah, and that's what we're just addressing. Yeah, that concern itself.
yeah. So I think you guys are very close, and I do appreciate that. The other thing is, it was mentioned earlier that there's, a couple of phases to this project as to how it's going to be constructed, and it was kind of ambiguous as to what the time frame would be, and I understand there's market realities and whatnot, but my concern here would be that if this project is left to be constructed in perpetuity, meaning going on for years, and to put it in context, when the project first started across the street from where I am, I had 1 child, I now have 2, the first one's in school. So, I'd like to see it completed before I send the kids off to college. So I don't know if there's some way we can put some kind of reasonable cap on the construction window for this project so that we don't have the constant noise and dust of the construction that's going on across the street like we've had for the last couple of years. Yeah. So if we could do that, that would be very helpful as well. Let's see. Yeah, I think you guys pretty much nailed down about the role of the town versus the homeowners association, so I'll cross that one off my list. And those are my concerns. Hopefully you guys will keep that in mind.
Thank you.
Thank you.
Would the applicant like to address Mr. Schwartz's concern about the time frame?
Again, we'd like to just go right through with it, obviously, but I believe that we showed four phases. Some of the phases will be a lot shorter than others, And some of them will be mostly infrastructure, others will be just building out houses at one point. We would generally look at this as a 5-year program. That's usually what you're dealing with a permit. And then you can go for extensions of a section of that if need be. You would stabilize different phases before you would generally roll into another phase. So this is normal course of business. We don't see this thing stretching out unduly. That's not, our goal is to get in and get out, obviously, but I believe the normal window is 5 years, and then you can ask for extensions on that.
So by statute, it has to be completed within 5 years then, without seeking an extension, is that correct?
Yes.
Okay. Would anybody else like to come forward? Jim? Yeah.
All right. Good evening, Jim Zioli, 177 Old Tavern Road. There. I was upstairs watching this, and we had a paper that was sent to us, compiled by CCM, Connecticut Conference of Municipalities. Joe Blake had asked for some information, and so I made copies of it. It was up on my desk. Dear Selectman Blake, this is in response to your request for information regarding the definition of senior housing terms. Attached are zoning regulation definitions from following municipalities. And it has 5 for senior housing, it has 6 for active adult housing, and then 5 again in age restricted. And some of the questions that you guys seem to keep chasing around the bushes here are in there. Over there, Tim. And, you know, they only allow 2 weeks, and I think Cheshire for people under a certain age. Somewhere else they're not allowed at all, but there's some helpful information in there, and it was compiled by Connecticut Conference of Municipalities, which we belong to as a town, and I hope you find it helpful. And it just came to be while I was sitting upstairs watching all of you, so I ran off some copies and see if it pushes you along. Maybe Mr. Miller's familiar with some of those other communities already. So, thank you.
Thank you, Jim. They seem to be scattered in the approaches that different towns take. And
Yeah, one that I was familiar with is Cromwell, and Cromwell doesn't have any prohibition against school children. It just says, you know, one has to be 55 and over. But there is a variety of approaches, and I think you know, every community needs it a little bit different. And I think we kind of look at that and take the best of what the town of Orange wants. So you take.
Ironically, I believe all of them are age 55.
Yeah.
As opposed to 62.
Salem is 55 with the minimum of 21, which is sort of what we've been contemplating.
So is Cheshire here.
In fact, all of them are 55. I think part of the reason that the others were 62, isn't there something to do with subsidies at age 62 that you're eligible for, federal subsidies or something of that nature? I think the
there's some federal housing programs that are specifically for those 62 and over, but there is some nature of subsidy.
Would anybody else like to come forward and address the commission? Please come forward, state your name.
Mr. Chairman, just quickly.
Yeah.
Just 2 things. One is my associate confirmed my research. The definition is correct as to what you could require a bond for. Number 2 is when we're talking about regulations and timing for the subdivision, although the statute does provide 5, I believe you have a regulation that requires it to be completed in 2 years.
Right.
So they'd have to, if the project was not done within the 2-year period, they'd have to come back within that period and request an extension.
Right, and they can get extensions for a total of
up to the statutory period of
Right.
10 years.
Of 10 years.
Yeah.
But they would have to
it-
come back to us and explain why they couldn't be completed within that period of time, which gives us an opportunity to.
Since we recently dealt with that issue,
That's right. There's
it's
two
got to be
letters.
consistent.
Good evening.
Good evening.
My name is Cheryl Schechter. I live on Old Silo Road. I apologize that I did not attend the first two meetings. I understand this is the third meeting. What is the pre-construction price of the units?
Yeah, we've not yet determined specifically what the pre-construction price is going to be for the non-price-controlled units.
Okay, do you have any idea about the range? Because someone had told me the 300,000 to 400,000 range.
There
Is
is
that
certainly
correct?
going to be a large number in that range.
Okay. I just want to make sure my facts were correct. If you don't mind, I apologize. It sounds like you're probably going to pass this community, but I would like to read a statement. It may be a little bit too late, but again, my name is Cheryl Schechter. I live on Old Silo Road. I've resided there for 13 years and have always enjoyed the rural character of this town. I've always been in favor of open space acquisitions because I believe it adds to the beauty and the preservation of our landscape. I was quite shocked to first read about plans to change the planned Sunrise Hill Estates from 21 private homes to 142 cluster houses on approximately 36 acres. I hope my information's correct.
Well, it's incorrect. Let me stop one thing, because it's been brought up several times, not by yourself, but this is not a cluster development. Cluster development, you take your allotted development, say it's, and it's also incorporated in the first selectman's letter, former first selectman's letter, but a cluster development, you take the amount of lots that you're allowed to get in a certain parcel, you group them all together and leave the remaining spaces open. And it's typically done to the same density that you allow in your regular subdivision. So in case you, the example in Mr. Goldblatt's letter is they have a 30-acre lot that would allow under current acre and a half zoning 20 homes. So you would take those 20 homes, group them all in a small area, and have that additional acreage open. So this is not a cluster development, by definition of cluster development.
These will be individual homes.
Some are duplexes, some are triplexes, and some are individuals. But that really, you could set up a cluster development any way. I mean, it's just that this really does not meet the definition of a cluster development.
I think what
Okay.
Cheryl was getting at, that they're clustered, meaning they're put together.
Yeah.
There's a
And
lot
they
of
are.
units within a smaller amount of, 21 homes versus 142.
Well, that was actually
Quite a huge-
22 homes and additional 6, I believe it was, that they were going to come back for.
Up to 31 total.
But go on.
I first contacted a friend of mine in town to verify this was, and was informed a couple months ago that the sewers had already been approved. I had planned on attending the public hearings here about this community, but I had no knowledge of the meetings, although I read all the local and town papers. And frankly, I was outraged that no one in my immediate community knew that these hearings were taking place, and that no one I've spoken with on my street or in my neighborhood is in favor of this project. I understand no one's attended these meetings and spoken out against it, and I was quite shocked. I understand that the community is for seniors, not exactly seniors, but for active adults 55 and over. The average price of homes starting at the $300,000 to $400,000 range, which I believe prices many seniors in our community out of the market. So, which leads me to believe, or ask the question, who are they really building these homes for? I live directly off of Grassy Hill Road. We are looking at an additional possibly up to 300 plus cars coming out onto Grassy Hill Road daily. I would like to know what they've planned to do in terms of lights and traffic congestion at that intersection in that immediate area. As it is now, I have a difficult time pulling out onto Grassy Hill Road from my street. Just
I know that we went over the traffic reports over on 2 of the meetings that we had. And in regards to our meetings are posted, Tammy, when is it? Is prior to January for the entire year. When they're posted, the times of them, and our agendas are available as of the Friday prior, or
okay.
on the Friday every, it is
So
Friday
there's a
every
legal
meeting.
notice specifically for these
These appear in the
matters.
paper because these are public hearings, so these are published twice, is it?
In the New Haven Register.
Okay.
Yeah. Yeah. So there really is, there's many avenues to find out where our meetings are and what's on the agenda, and these, as I said, any public hearings are posted twice in the local paper, which in our case is the Register.
I must have missed it. Just to finish, not only is the idea of putting 142 units on 36 acres unsightly, but frankly, I'm outraged that anyone in this town thinks that this project is in the best interest of this town. How is the overpriced, cramped-together project going to add to the quality and rural character of Orange? Once this project is approved, who will stop adjacent landowners? For example, the rest of the land that Heinz owns, and there's land directly behind my property facing 34, from stepping up and claiming their piece of the pie and offering it to more low-income and subdivision-type homes. As far as I am concerned, and I think I speak on the behalf of several of my neighbors on Old Silo Road, I believe this project serves no purpose for our town but to drive down all of our property values in my neighborhood. The house that my family and I have worked diligently and cared for over the past 13 years will instantly descend in value as soon as this property is approved. I am urging the Planning and Zoning Board to reconsider this project for what it is, a big mistake for the town of Orange. Again, I realize it might be too little too late, but I felt I had to speak my mind. Thank you.
So, we haven't voted. This is all still information that we're getting, so. Yeah.
Okay, thank you.
Thank you. Would anybody else like care to come forward and address the commission?
My name is Patricia O'Leary Treat. I live at 801 Grassy Hill Road. I was part of the Orange Senior Leadership Program, and together with 3 other people, we chose a project that we thought would benefit the town. And that project was finding out about the possibility of having additional senior housing in Orange. And in connection with that, we found 100 people that were over the age of 60 who very much wanted, being citizens of this town, to be able to stay in this town. As I understand it, there is no other place that senior housing can be built and still have a public sewer access. So for anyone to say, oh, I love senior housing, but I hate this project, doesn't realize how restricted we really are in area that is available to us. And I strongly feel, as an independent person, that this should not be an issue of Republican versus Democrat. There are both Democrats and Republicans that are very eager to find in Orange senior housing. So let's not make it into a political football that is shot back and forth between parties. Thank you.
Thank you. Vin, can you address the commission, as well as the public, about the measures that were put in place to keep this new sewage district limited to this site? I know there was a discussion at the, with the sewer authority, and perhaps you can highlight us those.
Yes, and for anyone who would like a more detailed analysis, I believe through the OGAT, the video of that presentation is available. But essentially what we did is we looked at this parcel and Route 34. The concern was that, and I think the catchphrase then was that this was going to be opening up the Pandora's box of Route 34, and that if approved, we would have commercial boxes along Route 34, and Route 34 would become the second post road. That was really the underlying foundation of what we were looking to see whether or not was a legitimate concern. What we discovered was, and I don't have my, actually I can use this here. What we discovered was under the State Plan of Conservation and Development, essentially this line here, which is the boundary line between the age-restricted development and the single-family houses. This line here going east into West Haven was within a conservation area of the state, which meant that sewers could not be extended eastward beyond this property line. So the analysis was that obviously you could bring sewers in here, and just by happenstance, it just fell right where this line is. And the only other exposure was across the street, which already has access to sewers through Derby. This, for those who don't know, the Hine property across the street is not exclusively in Orange, it's also in Derby. Derby sewers are already on that property, and what that property owner could do if they wanted to is backdoor the sewers coming right through with their existing property. There'd be little that the town of Orange could do to prevent sewers across the street. And then obviously there would be exposure here, which is not within a conservation plan. However, the analysis here was under, I believe it was the Avalon Bay City of Milford Supreme Court decision, where the Supreme Court upheld the trial court's denial of an appeal of Avalon, where they were seeking an extension of the sewer line. Avalon said all we want is to extend the sewer, and the WPCA of Milford said, well, we're not approving the extension, and this is not a simple tie-in, it's an extension. There was a distinction between what is a tie-in and what is an extension. So what the WPCA of Orange did, having knowledge of that decision, is it said, okay, we will approve sewers coming across the street, but we want the pipe to be of a certain size to limit the allowed flow coming off of this property, so that another user could not simply just tie in. They would have to seek an extension of that sewer line. Additionally, what we've done is we have limited the amount of capacity that the town of Orange is purchasing from the city of Derby to, I believe we are somewhere around 30,000 gallons a day, capacity which is particularly low. And the city of Derby has stated that because of what they're doing in their downtown development area, they're going to need their capacity for themselves, but not wanting to rely on another municipality. What we said was, all right, under the statutory procedure today, the Orange WPCA is free to contract with the Derby WPCA, and independent from any other board of Orange could extend the sewer system. So what we did was we entered into a contract. We haven't yet entered into it. It's in the process of review. I just got word from the city of Derby that we should be receiving their comments back within the next 24 to 48 hours. But what we have contractually set is a process that if some other developer comes along, the Orange WPCA could not independently extend this sewer district. They would require the approval of the Board of Selectmen of the Town of Orange, the WPCA of the Town of Orange, the Board of Aldermen of the City of Derby, and the WPCA of Derby. So we've tried to put up as many firewalls as we possibly can conceive of to prevent the extension of this sewer district.
Additionally, Vin, doesn't the sewer line come diagonally across 34 and not up Grassy Hill Road?
Right. The way the sewer line is proposed is to come down, I believe, Sodom Lane, and the developer can, I believe I had seen it was going to kind of come across Derby and be pumped under Derby and coming through this way.
No, it's going straight.
Comes right here.
Oh, better yet.
Okay.
So it's going to come through the Hine farm and come directly across Route 34. So it's actually in the set, what I guess would be almost the western center of the proposed site. Not in extreme close proximity to Grassy Hill.
Additionally, to address some of the woman's concerns, the applicant had originally required a certain amount of frontage, and we requested that they change it to a much larger frontage required on both roads, and unbroken frontage, so that any of the homeowners along this way, and also I believe would extend down 34 to where some of those homes are, because it's, I think, 1,700 feet or so on 34, could in effect stop the development, a proposed development going forward on the lot across the street, which would be the only two areas that these type of developments are allowed. So we put in some, some firewalls as well, or proposed to put some firewalls in as well.
But the property across the street, the farm down Grassy Hill Road?
Yes.
No.
Yeah,
on the
across
orange
the
side.
street.
To your left.
Orange to the left.
Oh, right here?
Yes.
Right. They could tie into Sodom Lane sewers if it was approved.
It would have to establish a whole new district, that's what Vinnie just said. that this-
Right, but
Well, just as
right.
anybody could attempt to, they would have to,
Right.
to sue their way
Yeah,
in. But I mean,
because this project sewer is a private sewer line. That's why they can't tie into it.
Well, actually, the Orange WPCA has not yet determined whether or not it's going to be public or private, although I believe it is preferred to be a public. It's private once it enters the site, but it will be public under the state road. The concern over here, though, is, I don't see as particularly relevant to this project, only because this would require an independent line up Sodom, and yes.
Right, just like they did.
Arguably, any
Could be
developer.
exactly what they did, just on the other side.
Right, any developer could come along and say, I've reached out to the city of Derby, they've agreed to sell us capacity, and, this is the way we want to come. However, here we're not coming under a town road, we're coming under a state road. Here you'd be coming up a town road, so you'd require Board of Selectmen approval to come up the town road. And here...
Grassy Hill is a state road, 121.
Sodom Lane is not.
Okay, yeah.
Okay?
Yeah.
So you would have that issue, but it would be independent. And, there's nothing you can do to prevent a developer from trying. You can't, and I can't stand here and say a developer's not going to try
I mean,
tomorrow.
a developer could try that same approach anywhere in town, for instance, really. I mean, there's really nothing to stop them.
But they're not going to tie in from here.
Right, because that's a private
Because
sewer main.
at this point, it's private.
Right, it's private, right, that's why, yeah.
And a couple of things. You mentioned the conservation easement. There's an actual conservation easement that runs from where to where?
If you look at the State Plan of Conservation and Development, the Office of Policy and Management has designated areas of the state of Connecticut as different districts, thank you. And certain areas are considered residential, other areas are considered conservation. If you look at the map, it begins along this eastern boundary of the proposed site, and it kind of flounders across Route 34 in this area here, and then it goes eastward along Route 34. And one of the comments that I had made at the Sewer Commission was, I don't think it's just happenstance that when you go to West Haven, it's developed, and you come into Orange, and it's not developed, and you go into Derby, and it is developed. If you look at the plan, the State Plan of Conservation and Development, in those other municipalities, they're designated differently than they are in the town of Orange. So, we can applaud all the tough efforts of our commissions over the decades and centuries, but I think that the State Plan of Conservation and Development had a lot to do with the development of Route 34 in Orange, because in certain areas, you're not permitted to bring in sewers.
So I'm just trying to get to that exactly. The conservation easement that you discussed.
It's not a conservation easement, it's a conservation designation. It's not an easement, it's a designation by the state of Connecticut.
Okay, and I just want to explore that a little bit,
Okay.
because how is that different? Does that allow for sewers? Do they need state approval to go into Route 34 and bring the sewers down?
Yes, in order to, what they would have to do, if a developer wanted to bring sewers into an area where sewers are not currently permitted because of the designation by the state, and they're referred to as conservation and open space, and so that's not exclusively referred to as conservation. But for the sake of discussion, we'll just call them areas where the state does not permit sewers. The process would be that the developer, or we'll call the applicant, would have to make application to OPM, the Office of Policy and Management, to change the designation. And the OPM officer would then reach out to the town for input on whether or not the town felt that designation should be changed in that location. And then it's a process of by OPM, and I had asked the question because, again, we can't assure to a certainty that things could never get done. I asked the question of the gentleman's name will come to me that I spoke to. It's in my notes.
Where is he from? I mean, from OPM?
From OPM. I asked if that had occurred in recent history, and the response I got was no.
Where does the court system fit into this? If a one of the, I think, concerns that a number of residents have is that it opens the door to other development there. Even if this board is very aggressive in trying to clamp that down. What happens if it goes to court and there's an appeal process? What effect relative to this conservation area, or but not easement, is my concern. In other words, where does OPM fit into that?
OPM fits into, if, for the sake of discussion, if for the area east of Baldwin Road, if a developer said, all right, we have acquired 40 acres over there and we want to put in an identical development in this area, and the development would require sewers, the developer would have to make application, because this is an area that is a sewer avoidance area. They would have to make application to OPM to change the designation to permit sewers to come in. The Office of Policy and Management would reach out to the Town of Orange and ask the Town of Orange to weigh in on whether or not this designation should be changed. And OPM then would deliberate and determine on its own whether or not the designation should be changed. I am unaware of whether or not there are any appeal rights to a superior court from
And that's
there.
what I'm trying to get to. In other words, is this just creating another defendant for the later appeal, one to the town, one being the town and the other one being the state?
I think you're more likely, when you're talking about judicial intervention, is going to be across the street or to the, I'll call it to the west. Over here, where you have sewers that are permissible, and if the town were to take a position, you could use across the street. Well, all right, a developer has discussed independently with the city of Derby to purchase for $1 million, 40,000 gallons a day of capacity, and Town of Orange, we have our sewers ready to come in, approve our identical project. You deny it because you don't want to extend any additional sewers. That's more likely where you're going to have a City of Milford Avalon type case. I see it less likely coming this way because, as described to me by the OPM officer, this is a particularly onerous process, and there's no recent history where, and recent history meaning decades, not years, where this has ever been changed.
I'm interested to find out the appeal rights that you mentioned they may or may not have, if we can do that.
Absolutely.
Okay. At this time, why don't we take a brief recess? We'll resume in, say, 10 minutes.
You can't unless it's a simple time. Right, you can't force them to extend. What Avalon, the City of Milford says, right, you can't force an extension, but you can force a time.
I might as well keep that, do I have mine somewhere? Here's the stack. I'll keep this one in.
How long of a break you taking?
10 minutes.
All right, I'm going to go upstairs just to see if I can get that answer.
You going to get an answer to that?
And just looking through these, I assume what we see appears to be a fairly progressive sampling, but I don't see anything.
Well, there's nothing we can lift from it. They're all scattered as far as the roads.
Yeah, well, I mean, like, lift what you want to lift.
Yeah.
Like I said, 55 is one of the best ways to go. I think that's fine and appropriate. I don't think it's a huge.
No.
I don't think I can expand them.
Yeah.
I assume it's public, yeah. I don't know. What's the problem if it happens? Magic to 62 versus 55. We would just talk about 62 was